Hi, this is Attorney General Tim Griffin. From time to time, I like to speak directly to Arkansans, especially when there are a number of facts not being discussed in the press and by the public. This is particularly important on legal issues of interest to millions of Arkansans. Today, I want to talk about the ballot initiative proposals that have been in the news of late: casinos, marijuana, and abortion. My office is in litigation on two of these proposals, and I want to give a general overview of two statutory issues that are being litigated. But before I do, I just want to take a moment to thank and commend Secretary of State John Thurston. He's demonstrated courage and integrity in performing his duties. He's committed to following the law, even when it meant correcting a "we've always done it this way" practice that did not comport with the law. It requires leadership to follow the law wherever it leads, and I commend Secretary Thurston for that. Now, there are a number of requirements in Arkansas law relating to ballot initiatives, and sponsors and canvassers must follow them at every step. I'll get into what a sponsor and a canvasser is a little later. It's a rigorous process. It should be, because the process involves changing the laws that millions of people live under, or even changing our state's constitution. You may have seen coverage of the first step of this process earlier this year when sponsors submitted proposed ballot titles and popular names for their initiatives to my office, and my office reviewed the submissions to ensure that they were not misleading. Second, after receiving that approval, sponsors use canvassers to attempt to gather the signatures required under the law. Sometimes sponsors, or the ballot campaigns, use all volunteer canvassers, but many, including all three of the sponsors in the news currently, use or used at least some paid canvassers. Paid canvassers are people who the sponsors pay to go out and collect signatures. It's that simple. Because that raises concerns of safety and fraud, the legislature has passed robust laws regulating this practice. Third, the sponsors then submit their signatures and other required paperwork to the Secretary of State for certification. If certified, the ballot proposals end up on the ballot, and Arkansans get to vote on them. What I'm going to focus on today are two specific provisions of law that concern both the second and third steps: the use of paid canvassers and the documents submitted to the Secretary of State. I'll refer to the two provisions as the training requirement, that's one, and the background check certification, that's two. In media coverage and public discussion about these ballot initiatives, these two provisions have frequently been conflated, leading to a great deal of confusion. My goal today is to clarify for Arkansans what these two statutory provisions are and how the ballot initiative sponsors complied or failed to comply with each of them. The first provision, and I'm going to put it here on the screen, the first provision that I'm calling the paid canvasser training provision here is ACA section 79111F2B. This is the training requirement. It's the legal requirement that paid canvassers are trained to know the law and rules governing their activity. Makes sense. The state wants to make sure that if a sponsor hires paid canvassers to collect signatures, that they're not just unleashed around the state with no knowledge of what they're doing or what the process is all about. This training doesn't just benefit citizens, Arkansans, to have them following the rules and the law. It benefits the ballot initiative sponsors, the campaigns, by avoiding waste in effort and time. The training requirement says that a sponsor the campaign driving the ballot initiative process, whether it be casino, marijuana, or abortion, has to submit a signed statement that it trained all of its paid canvassers. To emphasize, that statement must be signed by the sponsor, by someone from the campaign. Not a random person, not a paid canvasser, not a contractor. The sponsor has to be the one to sign and state in the document that their paid canvassers have been trained, all of the paid canvassers. If a sponsor didn't do this, they didn't follow the law. If they did do this, they complied. Now, it's important to point out here that this document is due at the time that the signatures are submitted. Of the 3 ballot initiative sponsors, casinos, abortion, and marijuana, the casino sponsor complied with the training requirement. There's no debate about that. The abortion initiative, the abortion campaign, the sponsor of the abortion ballot initiative, did not follow the law on this training requirement. They did not turn in the signed statement when they submitted their signatures as the law requires. Now, while the sponsor of the abortion amendment likes to point out all the other forms that they turned in, the bottom line is they didn't comply with the law on submitting a statement signed by the sponsor confirming that they trained the paid canvassers. The abortion sponsors are a no. As I said, the casino is a yes. And the third one, the marijuana ballot initiative sponsor, yes, they did comply also, just like the casinos, precisely with what I've laid out here. They turned in their documentation, this documentation, saying our paid canvassers were trained, and that was signed by the sponsor. Now, just to reiterate on this first provision, the abortion campaign on this statutory provision did not do what the other 2 did. No dispute about that on our side. It's pretty clear what happened there. Now, that is why, one of the reasons why the abortion proposal was rejected. That was not followed. Now, this is paid canvasser training. Document provided at the time that the signatures are submitted. Now, I want to talk about the second statutory requirement, the paid canvasser background checks, the background check certification. You can see the word certify here. The sponsor shall certify, okay? And this is that the individuals, the paid canvassers, have had background checks conducted on them. This requirement is similar in some ways to the training requirement that we just went over, in that it requires a filing with the Secretary of State's office. So yes, it's similar in that way. But it's different because it relates to a different issue. It doesn't relate to training, it relates to background checks. And it's different for another reason. It's not filed when the signatures are submitted at the end of the collection process. Unlike the training requirement, which is due at the time the signatures are submitted, the background check certifications are iterative, meaning they're filed as necessary as paid canvassers are hired and background checks are conducted, but before those paid canvassers begin collecting signatures. So, just for a second here, for example, if you hire Bob, you conduct a background check, you file with the Secretary of State that you did so. You hire Susie, conduct a background check, you submit the documentation to the Secretary of State that you did so. Now, when I commended Secretary Thurston for correcting an inherited erroneous practice, I was referring not to the first statutory provision, but to this one, the background check certification provision. Historically, the Secretary of State's office has not required the sponsor to be the one to make the background check certification. As I pointed out earlier, the word sponsor is here in the law. It is required that it be the sponsor. But Secretary Thurston, he acted in good faith reliance on the past practice, his staff did, and my office had no reason to be aware of this practice, as it had not been brought to our attention before recently. Once we learned of this practice, we advised Secretary Thurston of our view that the law must be followed as it is written. Our motto is FTL, follow the law, right here, sponsor shall certify. So, did the sponsors in each case, casino, abortion, marijuana, did they comply with the background check certification? Well, let's run through that the way we did with the previous provision. So, the Secretary of State's office, following the past practice, before we learned of it and before we advised them of the change that needed to be made in application of the law, they determined that the casino sponsors complied with the law. Okay? They said, yes, the casinos did follow the law. A lawsuit over the casino amendment, once it was certified by the Secretary of State, because he said it followed the law, a lawsuit over the casino amendment raised questions which informed my office and caused my office and Secretary Thurston to look at the facts, which led us to the determination that it was unclear from their submission whether it was actually the sponsor who had in fact certified, and whether it was unclear whether the casinos had in fact complied with this law. So originally, the Secretary of State said yes. When we looked at some new facts, they came to our attention. We conferred with the Secretary of State, and it was unclear. But we learned on August 13th by the admission of the casino amendment sponsor in a legal filing that they did not properly certify the background checks for its paid canvassers, meaning the sponsor didn't certify. So now we know by their own admission that this is a no. The sponsors did not follow the law here. Our view is that they did not comply with the background check certification, particularly based on facts that they presented in legal pleadings. Now let's go to abortion. For the abortion amendment, as I discussed previously, the petition was rejected outright. It never got over the threshold. It never got out of the gate, so to speak, for failure to meet the training requirement here under 7.9.11.111 F2B. Here it is. No. So, what about the paid canvasser background check? Well, because it didn't meet the other one, it had already failed. So the Secretary of State did not make a determination, didn't need to make a determination regarding the background check certification. But we now know that the abortion amendment sponsor did not comply with this requirement either. So just to be clear, they were no on this, they're no on this. They're double no. On both provisions, they're a no. Okay. As with the casino amendment, the Secretary of State's office, following the past practice, initially determined that the sponsor of the marijuana amendment complied with the background check following this practice. After the issue arose during the casino amendment lawsuit, and we discussed that, the Secretary of State consulted with my office and determined that the marijuana sponsors, applying the law as it should be, sponsor shall certify, that they also had not complied with the background check, even though the Secretary of State initially said yes. So let me just stop here for a second. You may have seen that the marijuana sponsor was granted a cure period by the Secretary of State and later received a letter notifying them of non-compliance with the background check certification. The casino, and there's been some discussion with not all the facts in the press and social media and elsewhere. You may have seen, you may have heard, the casino campaign did not get that letter. Why is that? Some have said this is inconsistent. It's not inconsistent, that is incorrect. It's following the law. So let me walk through this. Just to recap for a second, the casinos, initially, the Secretary of State said yes, they complied with paid canvasser, which they did. We agree with that. And he initially said on the background check that they complied with this. They did not. But when he initially thought they had, he certified it to the ballot. A similar thing happened with marijuana. They didn't have enough signatures, but the Secretary of State thought that they had followed the law on the background checks and gave them granted a cure period. Okay? So, applying the law as he understood it at the time, the Secretary of State determined that the casino amendment had enough signatures to be certified to the ballot without a cure period to collect additional signatures, so he did so. While the Secretary's understanding of the law has changed, here's sort of the rub. There's no law, there's no legal provision that allows the Secretary of State to reverse the certification once it has been granted. So even though it was erroneous, once the Secretary of State said that the casino's ballot measure was certified to the ballot, there's no power under the law, the Constitution, for the Secretary of State to reverse that. So it is still certified to the ballot. We've seen this before in past years, where something goes to the ballot, you vote, and it becomes law. Other things are on the ballot, and people may or may not vote, but it doesn't count because the courts have said it's still going to be on the ballot, but it's not going to be of consequence. It's not going to matter. So you can't reverse the certification. So now this is in the hands of the Arkansas Supreme Court. It's an issue that will be decided by the Arkansas Supreme Court. But it is certified to the ballot and cannot be reversed. Unlike casinos, there were not enough signatures. So at the time, the Secretary of State, he has a different understanding now, but again, at the time when they were submitted, the signatures were submitted, applying the law as he and his staff understood it at the time, they determined that the sponsor had complied with the background check certification. We know now that they had not, but at the time he thought they had, but they had not submitted enough signatures to receive immediate certification, so he gave the marijuana folks a cure. The sponsor earned a cure period to collect additional signatures. That's different than casinos that are certified. Marijuana gets a cure period. After this grant of a cure period, our office learned of the incorrect past practice regarding the background check certification and advised Secretary Thurston of the issue. Based on that advice, the Secretary sent a letter to the marijuana sponsors while they're in the cure period, advising them that the Secretary would apply the correct reading of the background check certification law, this statutory provision, to any new signatures submitted during the cure period. As with certification to the ballot, there's nothing in the law that allows the Secretary of State to rescind a cure period. So to recap, did the sponsor for the casino amendment follow the background check certification? No, they did not. Did the sponsor of the abortion amendment? No, they did not. Neither my office nor Secretary Thurston's have the luxury of the way it's always been done option. We follow the law regardless of what our predecessors may or may not have done. I hope this video has clarified that while there are some similarities between the training requirement, this one, and the background check certification requirement, this one, there are some critical differences. In any discussion of either one of them in this context requires us to discuss them both. What some have called an inconsistent application in the law is in reality a conflating of two different provisions of the law and a misunderstanding of the actual timeline of events. Thank you all for your time.